Start the class. Screen is visible to you? Can you see the screen? Hello? Hello? Abdul Salam. Can you see the screen right now? Can you please confirm me? Am I audible to you, or is this screen is visible to you?
Yes, ma, it is visible.
Okay. So, in the last class, we just studied about the contract, agreement, offer, acceptance, and proposal. And I just hope that you review them also after my lecture. Did you review them? 2 units. So, today we start the topic capacity of parties. Capacity of parties is the thing when we need parties to do a particular contract, or I can say a particular agreement. If I just said it to you that I just want to do a contract, or if I just said it to you that I just want to do a agreement with somebody, so I am saying, I just need some other person with whom I can do a contract or agreement. So, which kind of parties they can be, which kind of persons they can be, which kind of mental state they have, we just discussed today. Which kind of law we make them available so that they can easily know with whom I just need to do a contract, or with whom I just don't want to do any kind of contract. So, for this topic, first, if we just need to know about the thing that we just know about contract, agreement, offer, acceptance, proposal. So if I just need to do a particular contract, so first I just want a idea in my mind which I propose to someone. The other person, if he or she will agree, he or she will accept that proposal, and if he she will accept that proposal, that become the proposal. and then if they both agree on the same terms and condition, it become a agreement. And when agreement can be enforceable by law, then it become a contract. So these parties to whom I just need to offer my contract, to whom I just need to offer my idea, with whom I just want to share whatever I just want to share according to my contract and according to my agreement. The first point which comes to our topic is who is competent to contract. The person who can understand my contract, who can understand my terms and conditions, that particular person is able to understand and is able, or I can say that person is competent to do a particular contract. So here section 10 covers this um, competent to contract, which means that the person who is age of majority according to the law to which he is subject. If we just talk about the Indian law, they give us permission that we can do any kind of agreement, any kind of presentation, any kind of contract after the age of 18. That means 18 is the age according to Indian law to do any kind of contract or do any kind of things or contract. Second thing is person need to be sound mind. Now what is sound mind? Sound mind is the thing when person is not disabled, person is not suffering from any kind of mental trauma, any kind of problem, because of which he or she cannot understand, because of which he or she cannot understand what we just try to convey, or I can say what we just trying to tell them. If I just talk about the third point, person who is not disqualified from contracting by any law to which he is subject. That means if if our law, Indian law, states that a particular person is not able to do any kind of contract, that means that person is disqualified from doing the contract, and that person is not competent to contract. For if so, in this whole chapter or in this whole unit, we just need to study that who the person is competent to contract. The person who is competent to contract covers under section 10 of Indian Contract Act, which requires two parties, and the both need to be both the parties need to be understand all the terms and conditions which told by the law or which told by the business. Next point is position of a minor. If we just know about the person who is competent to a contract, the person who is not a minor, the person who is not unsound mind, and the person who is not disqualified from contract, that person is known as a competent person. If I just talked about in this whole chapter, we just uh, study all these three terms in an elaborate way. First thing we cover position of a minor. If I just talked about minor, who is minor? In India, person, he or she who is not completed his 18 years of age, that person is known as minor. If that person is below the age of 18 years, he or she cannot able to sign any kind of contract. If he or she will find any kind of will sign any kind of contract, he or she will not able to pursue it or not able to fulfill its terms and condition, because our government did not give any right to the person who is not completed his or her 18 years of age. So person who is a minor, the first thing is that the person comes under section 3 of the Indian Majority Act, yani ki basically our government decide a act for the person who can be minor and who can be major, the which gives in section 3, a person who did not, or who or she not completed his or age for 18 years. Second thing, where a guardian of person or property or both has been appointed by a court of law, his property has passed under the superintendence of the court of wards, he attains majority on completion of 21 years. Basically, if our government give permission to the person and that particular person inherit any kind of property or any kind of agreement or any kind of contract, so also all the details will be transferred him or her at the age of 21 years. If I just give you an example, for example, we all see movies, we all see web series in all the countries, whether it's India, whether it's any other country. I just talked about, there are so many persons who are working below the age of 18 years and they are doing a legal work. They are not, I'm not saying that they are doing any kind of illegal work. They are doing all the legal works which they assign, a person assign them. For example, there are so many child artists or so many persons who have a great mind and they are working for the according to their mind, but they are below the age of 18 years. So there has to be a guardian who sign on their behalf, so that the person who is responsible, that guardian is responsible for that minor who signed that contract. Am I clear to you? Who is a minor now? So if I just talked about the next term, position of agreement by a minor. What is the position of agreements? If a minor do any kind of agreement, for which place we consider that agreement, that agreement is valid or that agreement is not valid. If I just talked about that, that will be covered under section 11. If I just said that a person who, in which conditions he or she can do, he or she is a minor, but he or she can do a contract. First point is that a contract with or by a minor is absolutely void and the minor therefore cannot bind himself by a contract. Here, here is also a case study. Case study is the thing which you can read out on your own. I am just telling you by giving an example. For example, I am saying that I am below the age of 18 years and I cannot do any kind of agreement or contract. But if a person do a agreement or contract with me and he or she don't know about my age, he or she have no idea about my age, so that person give me any kind of money, and if he or she wants me to perform a contract, and if I deny that no, I am a minor, I don't want to do these kind of contracts and I am not going to fulfill any kind of things, so that person, if that person go to a court and sue me for that thing, government will give the decision in my favor, because I am minor and I am not responsible for this thing. It is that person, that particular person who did not know about my age, and that person did a contract with me, so I am not liable to pay any kind of amount to that person. Okay, so that means if a minor is doing any kind of contract, that contract will be always be a void contract. and that contract cannot pursue in future. Second thing is that fraudulent representation by a minor. If a minor know that like we are studying a business law right now, and we know that a minor cannot do any kind of contract, and if I just said that because of these reasons, because you know all pro and cons for this thing, so you did any kind of contract and you pursue that contract or agreement, I said that will be a fraudulent representation. If a minor know that he is a minor and he cannot do any kind of contract, and he misrepresent to the other person, he misrepresent to the second party, and he is guilty, so he is responsible for that contract and he is liable to pay the to pay that person, or he or she is able to pay to that person when they will acquire the age of 18 years. Next point is ratification of a contract by a minor on attaining the age of
Bacci yake
maturity.
mana.
Dauki sauri ka so min ka dawo kuma ka
Ya
tafi min
tashi ma.
okay to
Ya ce in ma ce ma ban gan shi ba.
dauka in dai ba
Can you
kula shi ba.
please mute your mic? Thank you. So our third point is ratification of a contract by a minor or attaining the age of maturity. If I just talk about the ratification of a contract by a minor on attaining the age of majority, that means that person who did a contract or who did contract without knowing that he or she is a minor, but he can pursue that contract after the age of 18 years. That means we need to mention in that particular contract that this person need to fulfill all his liabilities after the age of 18 years. Otherwise, if we force him or her to do to fulfill all the contracts element or agreement before the age of 18 years, that person can ratify us. That means he or she can deny us that he or she cannot do this thing, because that one is void according to the law. Fourth point is minor contract jointly with a major person. If a person is a minor but the other person is major, that means there are two person in a particular party, and that particular party wants to do any kind of contract. For example, I am major right now, and if I just said that you one of you is my friend, and one of you wants to do contract with me, or we both mutually decide that we both do a contract with the third person, that means me and you became one party, and there is a second party with whom we just need to do a contract. You are a minor, I am a major person, so we can jointly can do execute that contract, because one person is major and one person is minor. So because of that reason, because I know the things, I know all the terms and conditions, but the consequences of this point is that all the responsibility comes to me, all the responsible things comes to me, not to you, because you are just a minor, you are just following my suggestions, my things, you are not using your brain according to our law, but which is not correctly uh, possible, because all minors are much better brains than the majors. But according to law, the person who is below the age of 18 years cannot do any kind of contract, but he or she can do a contract, but all the responsibility comes to the major person and not with the minor person. Fifth point says that minor as a partner. There is a rule which comes under the Partnership Act 1932. If we just need to do a partnership, like we are doing a business and we just need to do a partnership. So a person he or she not attained the age of 18 years can be a partner in a particular firm, but only for the benefits, not for the losses of the that partnership. If there is any kind of loss, if there is any kind of problem, the minor person is not responsible for that, and minor person did not give any amount of money if that particular partnership firm comes with losses and not with the profits. Next point is minor as an agent. Like that agent here, the meaning of agent, if I just told you the thing, if you are doing anything XYZ work on the saying of the other person is the principal and you are the agent. For example, I am your faculty right now. I am a major party, you are the minor party, and you are doing what I am saying it to you. That means you are the agent and I am the principal. So if there is a agent and principal relationship, in that case also whole responsibility is with the principal, not with the agent. Next, minor as a shareholder. What is shareholder? Does anybody know about what is shareholder? Did you heard about this term,
Yep.
shareholder? Anyone?
Yes, we did.
What does that mean?
Um, really like a shareholder, is someone who shares, who owns like some of the shares of the capital in a public or private corporation or company.
Who give you the share?
You get the share from the company from people who already own the shares.
Okay. Basically, if I just told about the shares, share are issued by a particular company. The company who just want to raise a capital from the public or from any other person, that company can issue shareholders. Sorry, that company issue shares to the public, and that public, if they purchase that share, they become their shareholder. If I just told about the shareholder here, our means is that can minor be a shareholder? Yes, minor can be a shareholder, but just only for the benefits. For example, basically, you just need to understand all the benefits are available for the minor, but all the losses are not for the minor, and no minor is supposed to be sued by the law or any other person. Minor can avail all the profits and all the benefits which he she performed or not performed. So that is a minor. So here, shareholder member, a minor can become a shareholder member if there is no issue with his or her mental issue or any other kind of issue, but only for the benefits, but not with the equity shareholders. Shareholders are also of two types. One is equity shareholder, one is preference shareholder. Equity shareholder gives you the ownership of the company, and if you become the owner of the company, then there are so many decisions you just need to take, which a minor cannot able to take that decisions. So minor cannot be a equity shareholder, but he or she can purchase a preference shares, but with their guardian. Next point is a minor cannot be declared insolvent because he is incapable of contracting debts. Do you know what is insolvency?
Yep.
What is?
Insolvency is like It's like when where the debtor cannot pay the debts they owe.
Okay, if a company is not able to clear his if a company cannot able to clear debts which they borrow from the public or which they borrow from their debenture holders or any other person, that means that company will become insolvent. And if that company become insolvent, so there is no contract between that company. But here we are knowing about the minor. But if that company, in that company, particular company, minor is a shareholder also, so we cannot demand any kind of money from that minor. Minor never be insolvent because he is just only for the benefits, and he is not owe any kind of money from the any person. So from all these points, we just conclude that a minor can do a contract, but only just for his or her benefits. If there is any kind of problem, if there is any kind of solvency, if there is any kind of loss, that person or that company is not liable to pay anything to anybody and cannot sue the minor. Then there are exceptions also. There are lots of exceptions for this thing, because everything has the exception. No, nothing is perfect. If I just said to you exceptions, what are exceptions? Exceptions is the thing that you are not able to do a contract, but you are just available for the benefits, but in some cases you need to pay that thing also which you take from the other person. For example, first point comes here, contract for the benefit of a minor. If I just said it to you that there is a minor and there is a contract for which we can do for his or her benefit. So for his or her benefit, we can sell, mortgage the property of a minor, but with the due concern of his or her guardian. If there is no guardian, then we cannot sell, mortgage his or her property. If there is any kind of benefit for which minor uh, did that contract but is not able to fulfill, or he cheated, he misrepresent that thing, or he fraudulent that thing, so minor needs to be punished. Second thing, contract by guardian. If we just know about that on the behalf of minor, a guardian can do a contract for minor, because minor is not able to do any kind of contract, so his or her guardian is able to contract on a behalf of them, but within the scope of authority and for the benefit of the minor. If these two conditions are in that contract, then the guardian is able to do that contract, otherwise that contract will be void. Do you remember what is void contract, which we discussed in the last class?
Yeah, we remember.
Yeah, what it is?
Think like a void contract. It was the one that was like the one that is unenforceable, like that is illegitimate from the moment that it is made.
Okay, correct what you said. Here, if there is any kind of contract which we did on the behalf of minor, if just we talked about the minor, then that contract will be void, because according to Indian company law, a person who is minor cannot do a contract, but if on his or her behalf guardian is doing it, then it is acceptable, and the person who did the contract on his or her behalf is the person who will just need to take the full responsibility. Third point is contract for supply of necessaries. If we just said that thing, a minor is dependent on the other person or personally incapable of basically supply of necessaries. We can understand it in an example. For example, Mr. X, the person who did not attain the age of 18 years, that means he is a minor. He has no house, no basic things, and with whom he or she is dependent, that people are also not around. So for that necessary things, a person or a minor can do a contract, but with certain terms and condition which needs to be fulfilled. In that case, a minor can do a contract because he is suffering from the things, and because of that contract he can achieve his better life, or he can survive his for his life. So for that thing, our government give liability, give leniency to the minor, so that that person can do a contract, but only for his or she her his or her necessity things, not anything else. It's not important that a minor just need a iPhone 15, or he just said that it is for his or her necessity. So that means that is not correct. So minor just, if he or she is suffering from the basic necessity thing like food, clothing, shelter, for that things a minor can do a contract. If you have any doubt in these points, you can ask me. So next topic is agreement by person of unsound mind. First, we just need to know the point person who is of sound mind. Then we just I'll understand the person who is unsound mind. A person who is of sound mind covers under section 12 of the Indian Contract Act. The person who is the person who is of unsound mind is the person who cannot pursue a contract or agreement. A person who if I just said that he or she is the person who is of sound mind or unsound mind, we just need to know the difference between them. If I just said here, the first point is person who is of sound mind. Here sound mind means a person is said to be sound mind for the purpose of making a contract if at the time when he makes it he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. Basically, if I just explain you in a simple language, a person who understands all the conditions and terms which are mentioned into a particular contract or in a particular agreement, then that person is a person who is of sound mind. Means if I am doing a contract with the Mr. X, and that Mr. X is able to understand all my contract terms and condition, or whatever I am just suggesting or giving him offer, he or she is agree with that all the things, and he or she agree with all of his understanding, that person declares to be of sound mind. That means first we just need to know the person, that person is able to understand our things. Second thing is unsound mind. Unsound mind here also covers under section 12. The person who is of unsound mind, that person is maybe lunatic, is there maybe he or she is not able to understand, or he or she may be suffering from any kind of thing which he or she is not able to basically understand our terms and conditions, and not in a proper state of mind to understand our terms and condition, or a person who is drunken, that person is 24/7 is drunked, that person is also considered to be of unsound mind. So, if there is any person who is suffering from anything and is not able to understand our contract terms and conditions, that person will become unsound mind. Like if I am just saying that I am doing a business and I just want to make a contract with a 5-year-old kid. So with that 5-year-old kid, I am saying that I just want to do a contract, but that 5-year-old kid is not able to understand what my terms and conditions are, what I am offering. He or she cannot understand anything from that contract. So he or she is not competent to that contract. His or her mind is not proper way in a proper way that they can understand my things, what I just need to do. So here is a thing that if I just need to do a contract, that person should be of sound mind. Next point is burden of proof. Now, it's on the person who wanted to do a contract, is the burden on that person that he or she is of sound mind or he or she is not of sound mind. When a person usually of sound mind, the burden of proving that he was of unsound mind at the time of execution of the document lies on the person who challenges the validity of the contract, or where a person is usually of unsound mind, the burden of proving that at the time he was of sound mind lies on the person who affirms it, or drunken person, or delirium from fever or other causes, the onus lies on the party who set up that the disability to prove that it existed at the time of the contract. For example, if just we understand these points from example, I am doing contract with you, and I just told you all the terms and conditions, and you are saying it to me that you understood each and everything. For example, right now I am uh, basically I am conveying you a information which which is related to your subjects, which is related to your content. I am just delivering my lecture, and I'm just asking you basically that you are understood or not. You said to me that you are understood, so I just believe that you are understood. Okay, so burden of proof is on you, that you should tell me that you understood or you not understood. If you are not able to understand what I am saying, that it's your duty that you need to tell me what you are not getting my point. So basically, if I am doing any kind of contract, first thing that if a person is like a drunken person or a person who is not of sound mind, we just need to we will understand when I just saw them. But some persons are like they are of sound mind, but they are not of sound mind. The burden of proof on them. You can sue that person for the misrepresentation if he or she did not prove that they are of unsound mind or sound mind. In if that your contract is not fulfilled by them, so that time you can sue them in the court that they did not prove me the right thing at the right time. If they told me that they are not able to understand my conditions, so I never did any kind of contract. So basically, burden of proof on the party who is saying that thing, that he or she is okay with that and they agree with all the terms and condition, but they did not fulfill our contract details. Next point is position of agreement by person of unsound mind. For example, Mr. X is a person who is of unsound mind. that person did contract with Mr. A. Means Mr. X is not a person with a sound mind, and Mr. A is a person who is doing a contract with him is of sound mind. First thing is lunatic. Word here lunatic means that the person whose mental condition or personal experience or any kind of personal strain on him, and or if a person is okay for 2 months, but after 2 months he is not okay, then he is okay for 2 months, then he is not okay. If this on and off game is on, that means that person we also consider that he is of unsound mind, because if we did any kind of contract with these kind of person, that will be harmful for us, because they are not mentally stable and they did not understand what we are trying to convey them and what we are trying to make a contract with them. Second thing is idiot, which we use in our normal language also, that idiot we use in a very commonly way, but here idiot means a person who is permanently of unsound mind. If we just talked about the lunatics, lunatics can be for some particular time or for some month or days, I can say that thing. But idiot is the person who is permanently of unsound mind and who is not able to understand what I am trying to say. That time I am not able to deal with him, and I am not doing any kind of contract with that person. Third point is drunken and intoxicated person. Intoxicated word here used for the things other than the liquor. Like there are so many kind of intoxications right now available in the market, or I can say that available for the people right now. So if a person who is 24/7 drunken or intoxicated, that person is also not able to understand our terms and condition. Maybe that person is too much habitual with that intoxication, and that person is saying to me that he is okay and he understood my all the terms and condition, but I will deny of doing any kind of business with that person, because in future if he or she did not fulfill what they said, that will be loss for me. So here are three kind of persons. The person who is of unsound mind, first one is lunatic, second one is idiot, third one is drunken or intoxicated person. Then there is also exceptions. Exceptions are always there. If we are what I can say that if we are study business law, then there is always an exception. And if you know about the research process also, then there is a always 0.001% chances of happening of something which is cannot, which we are saying that it is impossible. So what is the exception here? Exception is that person of unsound mind is subject to the same exceptions as the contract with the minor is. Like they are saying that if a person is of unsound mind, but for a particular time period he or she is of sound mind, or he or she is able to know my contract, that time first thing he or she can do a contract. Second thing, for the benefits he or she can avail, for that thing that person can do a contract. Or if his or her property is attached with that contract, that time also that person do a contract. Yani ki basically you just need to understand 2 points. One is that he or she can do a contract on for the benefits only, or he or she can do a contract for his or her property involved. If their property is involved, then they just need to do a contract. Next most important point is person disqualified law. Here we just uh, add the word law. If we just add the word law, the person who did anything in their past which is not acceptable by the law, or for which he or she punished from the law, that person is not able to do any kind of contract. Because our law states that if a person is punishable by law, or he or she did anything wrong with anybody, or is need to be punished or already punished, that person, with that person we are not doing any kind of contract. First one is alien enemy. Now, alien enemy, what does that mean? An alien is a person who is a citizen of a foreign country. In this business law, alien means that thing, the person who is from the other country except from the India. Alien does not mean any kind of from the different planet. We are just talking about the country. So the person who is from the other than India, that person will be the alien, and that alien or that person is not friend with my country. So that particular person, I can say that is a alien enemy. Here what it means. So if there is a person who just need to do a contract with me, is from the other country, and that person is wants a favor or needs to do a favor for my country, so what will I do? I will uh, do any kind of contract. But if his or her motives are for the harm to my country, then I'm not gonna do any kind of contract with that person. Next one is foreign sovereigns and ambassadors. If we just talk about the foreign sovereigns and ambassadors, they are not allowed to do any kind of contract, because they are doing already for the foreign things, and they are involved in so many what I can say that they are already getting so many special privileges, or they are from the jurisdiction, they are know each and everything from the start to the end, so that person cannot do any kind of contract. Next one is convict. Convict means if a person is in imprisonment, or in a continuation period, or he or she in the past experience is in imprisonment, that person is also cannot do a contract until unless that person take permission from the court. After that he or she can do a contract, otherwise that person cannot do any kind of contract. Next one in insolvent. If the person is become insolvent, he or she cannot do any kind of contract, because that person is already into so many contracts which he or she cannot be able to fulfill it. That's why he or she become insolvent. So for that insolvency, the contracts which he or she is not able to fulfill, so what else contract he or she is able to fulfill? What he committed, he did not deliver, so no other contract can be done from his or her thing. And for his or her property, from the law side, official receiver or official assignee, I must say, is given by the court to sell his property, and or to rectify all his debts from the debtors. So it is your point third, unit third, sorry. If you did not understand anything from it, please ask me right now.
I think we understand.
Did you understand whatever I just told you?
Yeah, we did.
Okay. So let's start our fourth unit. Just give me a minute so you can also see the fourth unit. screen now?
Not yet. Yeah, we can see.
Okay. So now there is a fourth unit in which we studied about the consent. What you understand from the word consent? Have you heard about this word before? Consent? Obviously, I think
Yeah,
so. What does that
yeah,
mean?
we've heard. Like the permission.
Yeah, right. The permission. Basically, if we just talked about the consent, here is the whole word is free consent. Means the person need to be give his free consent so that we can pursue a particular contract or we can pursue a particular things which we both the parties uh, agreed on the thing, or I can say we agreed on the terms and conditions for which. So that should be a free consent for the person. There are different kinds of concern which we discussed today in this topic. First, they told us about the meaning of the consent. Meaning of the consent comes under section 13 of the Indian Contract Act. Consent means that two or more persons are said to consent when they agree upon the same thing in the same sense. For example, today I am teaching you a particular subject and you are here to get that information from me. So basically, we both are on the same page and we both are here with our consents that you just need to study and I just need to help you in your studies. That is known as free consent, or I can say consent. So before doing any kind of contract, before doing any kind of agreement, both the parties give their consent, then they are agree on a particular thing in the same way, in the same sense, what we are just trying to give them or what we are trying to communicate them. So many times we just heard that a person said anything to anybody, and after that that person told that that is not my actual intention, my meaning is something else and I just want to say other thing, but by chance you just took me wrong. Yeah, you just understood me in a wrong way. So what does that mean? That communication is not proper in what I just trying to say that thing, that is you are not getting that point. So if there is any gap between that things, so a person cannot able to do any kind of agreement or contract for that particular parties. If we just know about the concept of free consent, here free consent means that consent which need to be given by both the parties when they are entering into a agreement or entering into a particular contract. If I just said to you that you just need to be on time, and you said to me that yes, I will be on time, but after that you did not follow what you said, that means you did not follow the agreement on which we both are agreed. So means you give me free consent but you did not fulfill it. So that will be a problem for you also and for me also. If we are doing a business, here we are studying about business law, and if we are doing a business, that means we just have so many clients, Mr. X, Mr. Y, Mr. Z. There are so many clients and we just entering into so many contracts or agreements with them. If they are not giving us consent, or if we are not giving consent to them, that contracts and that agreements cannot be validate or cannot be pursued. Free consent comes under section 14 and it has different parts also. Like first one is coercion, second one is undue influence, third fraud, fourth misrepresentation, fifth mistake. So there are different subparts of the free consent which we will discuss in this chapter. First one is coercion. What coercion means? Coercion means if somebody is forcing you for something and you just need to perform that agreement or that contract by forcefully thing, so that contract is not valid, that contract becomes voidable, because one party is agreed but one party is not agreed, and that party is saying yes just only because of force that other person created on that person. So if we just talked about the points of the coercion, coercion comes with the commitment or threatening to commit. That means you are committing something or threatening to commit, or which is not legal in the Indian Penal Code, or the act which is forbidden by the Indian Penal Code. That is the issue, that you are not concerned from the Indian Penal Code and you are just committing or threatening somebody to do a particular job, that will become voidable for the party who did not want to perform it. Second one is unlawful detaining or threatening to detain any property to the prejudice of any person, whatever with the intention of causing any person to enter into an agreement. It means that you are detaining somebody, you are threatening to detain somebody for any kind of property or any kind of thing which other party did not want to do that. For example, you have a house and I just want to buy that house, but you are not giving me that thing. So I just kidnapped one or your family member and I am just saying it to you that just name it on me, your house with this amount. I am okay by giving you amount what you want, but just give that house to me. Otherwise, I am gonna kill your this family member. So that thing, maybe you write you just give me there that papers, or you just write my name for that house, you, or maybe you just give me on a free basis also, but that is not a contract, that is not a agreement. In the first lecture what we studied, that contract and agreement should be enforceable by law, and here you are from doing it forcefully and not by your consent, so that thing is not enforceable by law. So for any property, if I am detaining somebody or threatening to detain, so that will be not okay for the contract and not okay for the agreement. There are so many examples for the committing any act forbidden by the Indian Penal Code. You can read it by on your own, it is very easy to understand, but in general I am just telling it to you. Committing any act forbidden by the Indian Penal Code, like murder, kidnapping, causing hurt, rape, defamation, theft, etc., these kind of example, if a person is doing, that means one party is agree on it and the other party is not agreeing on it, so that party who is not agreeing on it is voidable, that contract is voidable from their point of view. Second one is threatening to commit any act forbidden by the Indian Penal Code. Like I am threatening you, just give me this amount of money, or I am kidnapped this one of your family member, that I am asking money from you for that thing. That means basically I am threatening you, or any kind of thing which you did not want to do that, so that also become voidable from your point of view. Means if there are always two parties, one is the party who is saying, who don't want to do any kind of contract, and the party who did not want these kind of contract and the other party wants to do that, but this is forbidden by law and this is unenforceable by law, so it cannot be able to happen. Next point is unlawful detaining of any property. For example, I am detaining your property, like I said that I just detain any person, any property from because I just want to do any kind of contract, or I am saying that thing, that particular that particular property is belongs to me and not belongs to you. So that means that is unlawful. You are having papers of that property, you are having each and everything, and you do not want to sell it out. But what I am saying it to you, no, sell it out, give it to me, that's my property, and I am detaining it. I just come there and I am just with so many illegal persons or dons, and I am just sending so many people to you and I am threatening you, that will be also unlawful. Next point is threatening to detain any property unlawful. What I said it to you, that I am threatening you that do this thing, otherwise I am detaining your property unlawfully, so that contract also become unlawful, unenforceable by law. Next one is intention of causing any person to enter into a contract. That means basically your intentions are not clear, your intentions are indecisive, I can say that thing, and to any person, that person will be able to enter into a contract and maybe not coming to the contract. That intentions of causing any person to enter into an contract, that one is also a voidable contract. Then there are things that you can do on your behalf. Threat to file a suit, that threat to commit a suicide, sorry, means what I am saying it to you, there are two things also which covers under the intention of causing any person to enter into a contract. Means we are forcing something to somebody, that do this way and do it on my way. Threat to file a suit, you are very respectful person or you are very gentle person, I am just saying to you that I'll file you a case, a defamation case, or I am saying it to you that I have just filed a case to you which you did not even commit that crime. So for that thing, you agree on my point and you will do whatever I just want to do. Second thing, if we are threatening somebody that do this thing, otherwise we will commit suicide. That one is also a voidable contract, because you cannot threat somebody or that of murdering your own self. One thing is that what we studied earlier, that we are threatening some other person, then do this work or this thing according to me, otherwise I'm gonna kill you or I'm gonna kill your family member. We are threatening this way. In this point, what we are doing, we are threatening somebody, do it on my way, otherwise I'm gonna commit suicide. That one is also a illegal thing, and that one is also become a voidable contract, and you cannot pressurize somebody or you can not force somebody by saying these things. Next one is effect of coercion. What effect coercion implies to the person or the party or on the contract? The effect of coercion explained in section 19 to 72 of the Act. What 19 said to you? 19 said that the consent of the party to an agreement is obtained by coercion. Means the parties need to give their consent, free consent, that they are agree on their terms and conditions of a contract and they are okay with that and they are doing a contract. If any one of the parties not give their free consent, then on the option of that party, that contract become voidable and contract become nullified and we cannot fulfill the contract. Second, Section 72 said that the person whom money has been paid or anything delivered under caution must repay or return it. That means if in the pressure of the caution, what I am threatening to you or I am detaining something from you, whatever the things happen, if I just got something from that thing also, so I just need to return that in future. Uh, if you put a case on me, you sued me, or on any terms and condition by criminal things or by civil thing, you can sue me, or you can maybe you can put charges on me, and I just need to pay penalty also what I did. Next point is burden of proof. Burden of proof lies on the party, the person who wants to avoid the contract, and the person whose consent is not free. Here is burden of proof is lies on that party, not on the party who is forcing for that contract. Next one is undue influence. Have you heard the word influence?
Yeah,
Yes, ma'am.
What does that mean?
Influence means to have an effect on the character, development, or behavior of something or someone.
Okay. Means basically influence here means that we, if we want to do a contract with somebody, and if I am saying I just want to do a contract with you, so I just need to influence you in some ways. I can influence you in a better way also, and I can influence you in a worst way also. My point is that I am doing a business, I just need to do a business, and I just need to influence other people. For example, we all heard about the sales profile also. In the sales profile, when we are doing a business for sales, what we are doing, we are offering our products to the customer, and we are influencing them that just see, this product is very nice, this product gives you this, and this product help you in that. Maybe that product will be helpful, and maybe that product will not be helpful for them, but we are trying to do influence them. So here, what word included, that undue influence. What undue means here? Unfree. That means we are influencing somebody, but in not in a proper way, in a unfair means, or I can say that we are just giving them wrong things, wrong contracts, wrong agreements, that which is not correct for the point of view of the contract. If I am doing contract and I am not telling that person true terms and conditions, that will, and I am influencing on the wrong one. For example, if you are going for a movie, and you just they are selling their tickets on the basis that they will give you free popcorn with the movie, but when you just go there and you just saw the movie, but you did not get any kind of popcorn, not a single small, big, any size, nothing. So if you are not getting anything from that thing, so that will also be a contract. What you did, you make a contract with that person for the movie and for the popcorn, but half is not present for you. That means they influence you, but they did not fulfill what they just said it to you. Then that contract is voidable from the your point of view, that they did not said what they, sorry, they did not fulfill what they said. Okay, so here undue influence covers section 16 subsection I, sorry, clause I. Here a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other, and uses that position to obtain an unfair advantage of the other. Basically, if we are doing a contract with a person, that person should be very known to us and we can dominate that person. For example, our parents always dominate us, and they did so many contracts with us which we don't even want to do that things. So they are small contracts, but when we talk about the business comes with the greater contracts and greater agreements. So if we are, for example, I am doing business and I just ask my friend and I just influence him, or what can I say, that I just dominate his or her, that no, this is the best one thing, and you just need to invest in my company, and you just need to do business with me, and you just need to pursue this project with me. So that thing is a dominating thing, and my I just need to check my friend is okay with the terms and condition or not okay. And if I'm not checking it, I am just saying it and I am just giving order to that person, that will becomes undue influence and becomes voidable from his or her point of view. So, from this definition, there are two essential points. One is the relation subsisting between the parties should be such that one of them is in the position to dominate the will of the other. So, when one person is dominating to the other person for his or her benefit, so that become undue influence. In the quotient, one person, what he or she is doing, that he or she is doing basically forcefully, he or she is forcing to do a contract, but in undue influence we are dominating somebody. So we can dominate somebody when we know them very well. Second thing, dominant party should have used that position to obtain an unfair advantage over the other. Means what we are trying to do, we are just looking for our profit, we are just looking for what we want, we are not looking to the person what he or she want, whether they are very close ones or whether they are not close one, but we are just trying to confirm our deal and we are not looking for them. So that become undue influence. There are examples also, please read them. Next one is presumption of domination of will. If we just talk about the will, undue influence involved only when one party is in position to dominate the will of the other. That means undue influence can only happen when one person is dominating and that person is easily can dominate to the other person. Now, in section 16 clause 2 of the act, here is a question that who can dominate to the person. First one, he holds a real or apparent authority over the other, which I already told you. Here are some examples also, like master and the servant, parent and child, income tax officer and assessee. They are in the dominant position in our houses. Our parents are always in a dominant position, and they just told us do this, why did you did this, and why did you did that, and why you are not doing this, and why you are not doing that. So basically, when there is a relationship and there is a close relationship, then only undue influence happen, otherwise undue influence is not gonna happen. Second point is he stands in a fiduciary relationship to the person. What fiduciary here means? Fiduciary means trust and confidence. If you are trusting me today, for example, you are sitting here, you are just listening to me for 2 hours, that means we both are in a fiduciary relation. You have a trust on me that whatever I just told you today, I told you in a correct way and not in any kind of any kind of negative thing. I just told you, I just told you what is relevant to your subject and what is relevant to your exams. So this is a fiduciary relation, like what we are with our parents, um, with our I can say that advisors, with our doctors, with our solicitor here means lawyers, whatever trustee we have, that means the person we are with whom we are around and we are trusting them. We just go to the doctor, we just told him or her our problem, and we just trust whatever medicines they just give to us, we just start taking them, and we just feel that we are okay. So that means when you are trusting somebody, that become a fiduciary relation between the two parties. At that time undue influence can happen. Third point is, he makes a contract with a person whose mental capacity is temporary or permanently affected by reason of age, illness, mental or bodily distress. Means we are doing a contract, basically person who is not able to do that contract, but still we know that person, so we are doing a contract. For example, there is a health issues, or the like a person is illiterate, that person is um, trusting us, but that person is illiterate and that person is having so many properties. What we did, we just make him a sign, or we can make him a stamp from his thumb. So we just take all the property on our name. So what we are doing, we are doing undue influence with that person. Now, effect of undue influence. What is effect of undue influence? Undue influence has also become voidable contract from the party with whom we did undue influence, not from the party who get the benefits. Next, burden of proof. To whom is the burden of proof? The party who is in a position to dominate his will is need to prove that whatever he did in a better way, and he did not mean what he did. But in so many cases there is a proof also that that person is did that thing in a greedy way, in some bad way, or basically provide said that that will be harmful to the other party also. Second point, the other party actually paid his influence to obtain an unfair advantage. That means uh, party gives unfair advantage, means here the party who did not want to do any kind of contract but provide unfair advantage, so also it become undue influence. So here in section 16 clause 3, person who is in position to dominate the will of the another enters into a contract with him, and the transaction appears on the face of it or in the evidence adduced to an unconscionable, the burden of proving that such contract was not induced by undue influence shall be upon the person in a position to dominate the will of the other. Means the whole scenario of the undue influence is the thing that the person who is trusting us or who is depending on us, we are influencing that person, or we did any kind of wrongful acts with that person, so that contract become voidable contract. Next one is unconscionable transaction. Unconscionable transactions uh, used so many times in this business law, which means that a person who has in a position to dominate the will, basically in general language, if I just said it to you, that unconscionable transactions means that the person who is not in the position to understand that contract, he or she just trusting us, and we are harmfuling that person. Next one is presumption of undue influence can be rebutted by showing that the stronger party had made a full disclosure of all the facts of the agreed party before making the contract. That means a party is giving you full disclosure, but the point is that you are in that trust position, in that position, that you are not able to see the negative points, or I can say red flags from it. The price was adequate, the weaker party was in receipt of competent independent advice before entering into a contract. Each and everything is okay, but the intentions of a person is not okay, so that contract becomes voidable contract. Next one is they give us a difference between coercion and undue influence. Let's read it out. We uh, we always need two parties in both of the things. In coercion, relationship between parties is not necessary. Means Mr. X and Mr. Y, if they are not related with each other, they don't even know each other, then it's okay. We don't have any issue with that. Coercion can happen, but in undue influence, relationship has to be exist between the parties, because when relationship existed, that's why we are trusting that person, otherwise we are not going to trust that person. In coercion, second point, consent is given under the threat of an offense, yani ki basically offense, uh, sorry, threat become the offense. And in consent there is also only a dominating thing here, so no criminal offense committed here. Coercion can be physical or mental. If we just talk about undue influence, that one is only a moral pressure. Coercion can be moved from a stranger to the well-known person, and undue influence is only with the parties who know each other. Then coercion, when the contract is avoided, any benefit received has been restored or refunded. Means here is a part of which can be restored or refunded. And in the undue influence also, there is a part can be restored or refund from the parties, from the party who did that thing. Is there any question from this, two of this, or you understood the point?
We understood the point.
Okay. So our next topic is fraud. We all know this term very well, and we use this term very well in our day-to-day life. Fraud means and includes any of the following acts committed by a party or a contract or by any one of his connivance by his agent with intent to deceive another party thereto or his agent, or to induce him to enter into the contract. Basically, term fraud covers from section 17 of the Indian Contract Act. Fraud means we are doing something with the other person. We know that we are doing wrong thing with that person, but for our own benefit, we start doing it. We are earning from it, and whatever profits we can sorry, whatever profits or gains we can take from that thing, we are taking it and we are enjoying it. That is known as fraud. When parties know that they are doing a wrongful thing to the other party, but still they are believing that this is a right thing is going to happen, or whatever is going on. Third thing is a promise made without any intention of performing it. Basically, uh, they promise, if we just talk about the contract, we know that before contract there is an agreement, and before agreement there is a promise. If we just promise made without intention, we are not gonna perform it, but still we are performing it. Like I just said to you, I will take your lectures on every Monday 3 to 5, but my intentions are clear. No, 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 that I am not coming for these students. I am not performing these lectures. I am not giving them any lecture. So that means if my intentions are known that I am not going to perform it for that, but still I am making a promise, that means that is a fraud. Or any act which is fitted or deceived, that means which is uh, known that it is not going to be happen, but still we are saying it that it is going to be happen. Any such act or omission as the law especially declares to be fraudulent, or we are basically we are saying that we will do this thing or we will do that thing, but actually we know that our law did not give us that permission to do such act, but still what we are doing, we are making a contract from it. To understand the elements of the fraud, first point is the fraud must be committed by a party to the contract by or anyone with his convenience or by his agent. That means fraud has to be happened by the person or his or her agent, and they are giving a false statement or they are giving the false information to the other party, that is known as fraud. Second, the fraud must be committed with an intention to deceive the other party. That means we we already have an intention that we are not going to perform it, so that is the thing we are that is the thing basically we are doing bad with the other person, that we are not gonna do it, but only I know that thing that I am not gonna do that, not the other party. Third point is there must be a representation or assertion and it must be false. Means there I am representing you or I am saying that it is gonna be happen, which is a false statement. I am not gonna perform that contract and I am not gonna represent any kind of terms and conditions relating to that contract. I am just giving you a false representations. Next one is the representation must relate to a fact. That means I just pretend each and everything that it is related to a fact, it is related to a contract, and I am just pretending in front of you that I am gonna do this, I am gonna fulfill or execute this contract in a way that I am saying it to you or I am committing it to you, but only I know that I am not gonna commit it, I am not gonna fulfill it. Next thing, active concealment of a fact also amounts to fraud. Means actively what I am doing, that I am not giving you proper information and I am not telling you the correct points which I just need to tell you, that also becomes a fraud. Means I have all the informations and I know that I just need to communicate it to you, but I am not doing that. Next one is the fraud must have actually deceived the other party. My actual motive is that I am deceiving the other party and I am not gonna fulfill the agreement. Next one is the party acting on the representation must have suffered from loss. Means the person who is the other party is in future will suffer from the loss, because I am doing the contract and I am not gonna fulfill it, that will become a problem. Next one is, does silence amount to fraud? Yes, silence amount to fraud. According to section 70s, it is said that if you know the facts and if you know all the things, but you are not telling it to the person, so that it also becomes a fraud, because you know all the things. For example, in criminal law, if you know it very well, if you know all the evidence, if you know that who is the murderer and you are not telling it to you, that means you are just giving you are just helping that person, and you are also amounts to that crime. So silence also amount to fraud, because you know the facts, you know the informations, but you are not telling it to the person to whom it has to be communicated. So you are also the part of that thing. If you are silent, that will also amount to a fraud. But there are two exceptions to this rule, in which silence also amounts to fraud. See, in this point, basically, if for example, I am just telling it to you more clear from the example, that if I know I am doing a contract, and you know that I am doing a contract, and you are representing me to the third party with whom we are doing a contract, and you are not aware what I am gonna do, or I am not gonna perform the contract, or I am gonna perform the contract, means you have no idea about it. You are just trusting me, and you are just giving me a good faith that I will perform the contract, and you are representing all the things on behalf of me, but still you don't know anything. Still we both are in a fiduciary relationship. That means that time you are not responsible for that fraud, because you are not able to know what I am trying to do and what I am making you do to the third party. So in that condition, you are not supposed to be fraud, and I know about that fraud. So means if you are in a fiduciary relation, or if you are in a absolute good faith, that will not gonna amount to the fraud. Next, where the silence is in itself equivalent to speech. For example, you are not saying something because your actions say so many things, or your actions say each and everything. That means you are not gonna do that particular task or particular work. That one is also become, that one is not considered as a fraud. For example, Mr. A comes to me for any kind of contract, and he just made his mind that I accept that contract, but I was silent that time, and I am not gonna accept that contract. I never said yes for that contract, and I never said no to that contract. So Mr. A is not able to know what I am trying to say. My silence is already an answer that I am saying no, I am not giving you yes. But he just understood my silence to yes, which is a false representation basically, and did not amount to the fraud. I am not doing any kind of fraud to him. He just misunderstood in his own way. Next one is consequences of fraud. What are the consequences of fraud? Basically, first thing is that we cancel the contract, and in the law term we use the word rescind. That means we cancel the contract. If any party discovered that they are because the other party, they will suffer from anything, they will get that amount, or other party can force that party or sue them through the court for the performance of that contract. And if the court think that that performance has to be happened, then court will tell to the party who commit the fraud that you need to perform the contract. Or if there is any damages happen from that fraud, the person who did that fraud need to compensate to the other party, or need to pay the penalty also if there is any by the court of law. Next one is, what is misrepresentation? Misrepresentation basically done unintentionally and innocently. Means I am telling you something very innocently because I don't know about that thing. I am not basically, what can I say in this? For example, let's understand it from an example. I don't know the actual facts what I am telling it to you. Fraud is the thing, I know the actual facts, but I am not telling it to you. Misrepresentation is the thing, even I don't even know the actual facts. That's why I am telling you the wrong things, because I don't have knowledge for that thing. So that is known as misrepresentation. Misrepresentation considered is an innocent act or unintentionally done. Misrepresentation on a positive way, and I am not doing it in any negative way. Second one is breach of contract. What is breach of contract? Breach of contract means one of the party did not perform the contract or any condition or term which needs to be fulfilled, which needs to be done by the other party. That party did not commit or did not perform that whole contract, or they misrepresented. That one is known as breach of contract. Or we can say that if all the terms and conditions they did not disclose, that one is also become a breach of contract. In general way, if we just need to understand breach of contract. Breach of contract simply means when one of the party did not perform the contract, that is known as breach of contract. Third one is inducing mistake about subject matter. Means the actual objective of the contract is uh, not telling it to the other person, or by mistake we just communicate it in a wrong way. That one is called the subject matter here. Like the actual core thing, what is the object of our contract, that will be we are telling to the other person wrongly. That one is also becomes a misrepresentation. What are the essential points of the misrepresentation? Essential points are innocent. Basically, one is innocently done. Honestly believing it to that point means I am saying it to the I am saying it to you. No, no, today rain happened in a particular area. Somebody told me. So I am believing the fact that somebody told me, and I am honestly believing that fact. But I am not sure that that thing happened or not. That is true or false. Maybe that person told me a wrong thing, and my intentions are not that I am not going to perform that contract or that particular thing. I am just saying that I have full intentions to fulfill or to execute that contract. Second one is misrepresentation should be of fact material to the contract. Mere expression of one's opinion is not a statement of fact. Means I just believe that whatever facts I have, whatever things I have, they are okay. There is no misrepresentation. In fact, there is no problem in that fact. These facts are okay. Next one is representation must be made with a view to inducing the other party. Means we are doing representation that we know the all the correct thing, and we are representing ourselves that we are correct, but in actual we are not correct, because we don't know the real facts, but we are just believing that we are correct, and we made the other party also that we are correct. Fifth point is false representation must have made by one party to the contract to the other who mislead. Basically, if we said that one party is misrepresenting to the other party, but they misrepresented in a certain way that they don't even know the actual facts. What effects of misrepresentation? It covers under section 19 of the Contract Act. First thing, that we can cancel the contract. Second thing is that we insist to the proper communication, or we can say that we agreed, if we both the parties agreed that we need to perform this contract, then we will start performing it, otherwise we will not gonna perform it. Here it is very important to both the parties that they agree in a certain way that you just need to perform the contract. Or we in some cases we just lost the right to rescind the contract, means that we cannot cancel it, so we both the parties need to perform the contract in a certain way. Whatever misrepresentation happened, it's our duty or it's our thing that we make that contract, so we just need to fulfill or execute that contract in the same way. Next one is, there is a distinction between the fraud and misrepresentation. Fraud is a wrong statement which done intentionally. Misrepresentation is a wrong statement also, but it did innocently. Second thing, person making wrong statement does not believe it to be true. Person know that it is wrong, but he or she is just not accepting it. Second point for misrepresentation, person making the wrong statement and believes it to be true. Okay. Third one is intentions to deceive. That means I just need to harm the other person. That's why I'm doing the fraud. Misrepresentation is I have no intention to deceive the other person. Fourth point is, we can cancel the contract or we can claim for damages. In misrepresentation, we can also cancel the contract, but we cannot claim the damages. We can cancel the contract or we can agree to execute the contract. Next point is, except where the silence amounts to fraud, the contract is voidable. When it becomes basically when silence comes in the matter of fraud, then that contract becomes voidable. And if we said about the misrepresentation, discovering the truth is also becomes if it is unavoidable that we cannot understood the truth, so we just represent the contract in the same way. Last topic is mistake. Here is a chart of a mistake from which we can understand it in a better way. Types of mistakes. First one is mistake by law, mistake of law. Second one is mistake of fact. When we talk about law, there are two laws available. One is foreign law and the second one Indian law. Why we are considering here two laws? We are considering here two laws because if we are doing a business, whether we are doing it according to the Indian law, and if we are doing a business with the international purpose, we are doing a business with the foreign law also. So if there is any mistake, basically from the point of view law, that we misunderstood that or we did not able to pursue that, we are prohibited from doing anything, so that comes under the mistake of law. If we understand the point, mistake of fact can be of two types, bilateral and unilateral. Bilateral means possibility of performance, and the second one is subject matter. Unilateral is identity of person and nature of contract. Basically, we are talking about here fact. Fact means a particular statement and particular things which we are using in our contract. Basically, if we are doing bilateral thing, bilateral considered two, means whether my contract is able to perform and my contract is not able to perform. Second thing is subject matter. Whatever is my subject matter, is it okay of doing it and is it not okay of doing it? Unilateral, what we consider about unilateral, identity of person. What identity of person? we just need to know. For example, I am the only person or who is doing a contract, means I am the person who know each and everything for the contract. Identity of person means I just need to be very clear what identity I have, what I am making a contract, why I am making a contract, which kind of things I am doing for the contract. That is known as the identity of person. Next one is nature of contract. I just need to know the nature of contract, which kind of contract I am doing, what are the terms and conditions I am doing, what my clients need to know, what kind of things I just do. If there is any possible thing happened in that way, any fact, if there is absence of any fact because of some reason, that will be considered as mistake of fact. Basically, if there is any possibility of missing of fact, or I just miscommunicate the fact, that will be a mistake of fact, whether it is bilateral, whether it is unilateral. Bilateral can be of two types: possibility of performance, whether I am going to perform the contract or not, or is there any problem in my subject matter of the contract. Unilateral, identity of a person I just need to check, and the nature of contract. Next, we just need to know the effect of mistake. What effect should be come? Basically, if I just sorry, because of some technical issue. Yeah, here we are. If I just said it to you that my agreement, the subject matter of my agreement, which is essential for the whole contract, is absent, then I am not able to perform that contract and that become void. Second one, in most cases, the unilateral mistake, the contract is void, but where unilateral mistake defeats the true consent of the party, the agreement treated as void. In both the cases, the agreement is void actually, whether it is unilateral or whether it is any kind of consent that did not we make from the other party. So our agreement is become void. Third one is any person who has received any advantage under such agreement, he is bound to restore it or to make compensation for it to the person from whom he had received it. Basically, I am what this point told us, that if I am doing any kind of agreement from which I just want advantage from it, or I just want any kind of compensation from it, so that person will become, that person need to perform that contract if both the parties agree to it. Next one is a person to whom money has been paid or anything delivered by mistake must repay or return it. For example, by mistake I just give extra money to other person, or by mistake I just said anything to anyone So in that case, I just need to return that thing. These are the effect of a particular mistakes, and this is our whole chapter which we discussed today. If there is any doubt, please ask me.
I don't have any question. That is for my side.
Okay, so we just review the whole thing what we studied today. First, we just need to know the consent, whether our consent is free or not. First thing for our contract, very essential point is that our thing is our consent need to be free in terms of both the parties. Second thing, coercion, when somebody forcible doing any kind of thing or force somebody to do any kind of contract, that contract becomes voidable from the part of the other party. Undue influence, when one person dominates the other party because of his fiduciary position. That fiduciary position comes with trust and confidence. That contract is also become voidable. If we just talked about fraud is the thing when we know the real facts but we are not gonna tell to the other party what my intentions are and what I am trying to do with that person. That thing is considered to be fraud. Misrepresentation is the thing when I don't even know the real facts, I just believe what the other person said it to me, so that become misrepresentation, and I am just telling it to the other person, to the other person, and to the other person, but the real fact, even I don't have any clue about it. Next one is, after misrepresentation, next one is mistake. Mistake is the thing, can be of two types: bilateral, unilateral, or mistake of law or mistake of fact. When we talked about the mistake of law, it means that when Indian law or foreign law both are involved or one of them are involved, we consider it as mistake of law. And when the subject matter, person, or any other fact involved in the thing, that thing considered to be mistake of fact, and it become void from the other party. It cannot be performed in any way. So this is our fourth unit which we conclude today. So in two lecture we completed our 4 units, and I hope that you gonna basically review the whole unit, and if there is any doubt you will ask me also. It will basically I can say that it is uh, I just want you to learn each and everything, whatever you are studying in your graduation or post graduation. Because if you are doing any particular, you are taking any particular education from any university, so you have to understand all the subjects. You just need to gain the all knowledge, and if you are not gaining any knowledge from that particular subject, so it is not relevant to give exam or to sit in an exam for that particular subject. According to my point of view, you just need to be clear, you just need to be known for all the facts whatever your subjects is telling it to you. Okay, and if there is any problem, so you can share it with me, or you can tell me, or you can ask me any question about the subject related. Okay.
All right.
Okay,
If
thank
there
you
is
so
no
much.
any problem,
Okay.
okay, thanks you for your
Okay, thank you so much.